Usually, stand your ground laws in Pennsylvania have a lot of myths along with it. I'm here to teach you how to understand it. Hi, my name is Lonnie Fish from the Liberty Law Team. We represent people who have been injured or who have been accused of crimes here in Pennsylvania. Today, I want to talk to you about Stand Your Ground Law. Stand Your Ground Law is a special subset of justification. We have a very long webinar regarding justification, but I did want to set aside a little bit of time to talk to you specifically about Stand Your Ground and possibly even do a little bit of a deep dive. But the first thing I want to do is talk to you specifically about what the legislature states with Stand Your Ground law. The section of the Pennsylvania Code that discusses Stand Your Ground law says the following: that an actor who is not engaged in criminal activity, who is not in the legal possession of a firearm, and who is attacked in any place where the actor would have a duty to retreat under paragraph 2 has no duty to retreat and has the right to stand his ground and use force, including deadly force, if 1, the actor has a right to be in the place where he was attacked, 2, the actor believes it's immediately necessary to do so to protect himself against death, serious bodily injury, kidnapping, or sexual intercourse by force or threat, and 3, the person against whom the force is used displays or otherwise uses A, a firearm or replica firearm, or B, any other weapon readily or apparently capable of lethal use. Let's take a little bit of a deeper dive right now. So essentially, the difference between the Stand Your Ground law and the general justification where we would use deadly force is essentially this law eliminates the duty to retreat. The difference is going to be the following: that first, the person who is using the deadly force back, the person who is essentially defending themselves, has to have essentially what we call clean hands in the business. So you can't be doing anything illegal. And the firearm, if you're in possession of it, has to be a legal firearm. A lot of times you can argue self-defense using a firearm and the person would be, and sometimes that person is having an illegal. In some cases, my client will have an illegal firearm and they may get sentenced on that firearm, but sometimes that's better than a shooting. And then 2, the person believes it's immediately necessary to protect himself against death or serious bodily injury, kidnapping, sexual intercourse by threat. So essentially, the threat posed to you has to be something significant, like a weapon, a knife, as discussed later, that the person whom the force is using it has to display or otherwise display a firearm or some other weapon that's readily or apparently capable of lethal use. Knife, well, who knows? Something else that's not a firearm, but maybe like an AK-47. And also that you have to have a right to be in the place where you're attacked. So you can't be in somebody else's home. So if you are legally possessing a firearm and somebody approaches you with a weapon, you do have the right to stand your ground if the gun is legal, number 1. Number 2, you believe that it's immediately necessary to do so to protect yourself against death or serious bodily injury, and the person displays essentially a deadly weapon. Let me give you the best example. Let's say you're on the streets of Philadelphia and you're with your family or you're walking your dog and you have a gun on you. And somebody comes up to you and says, "Give me what you got." And they have a gun and they show you a gun on their hip. You don't have to wait for them to pull up their gun. You could stand your ground, even if you could retreat.